Hi everyone, my name's Emma Day. I'm a human rights lawyer and I'm part of Tech Legality, which is a consulting company specialized in human rights and technology. So I'm going to talk to you today about the UN Convention on the Rights of the Child and also the UN Guiding Principles on Business and Human Rights and how they relate to age assurance. So this is a kind of roadmap of my presentation today. So we're going to walk through the CRC, which is the Convention on the Rights of the Child, the UNGPs, which is the UN Guiding Principles on Business and Human Rights, which have 3 pillars, and then I'll make some recommendations for different stakeholders in the age assurance space. So as many of you probably know already, the Convention on the Rights of the Child is the most widely ratified treaty in the world. So these are the 42 different rights that children have, and states which have signed up to the convention must protect those rights. The UN Committee on the Rights of the Child is the body that oversees the implementation of the convention by the different states that have signed up to it. And in 2021, they published a general comment, number 25, and this explained how the convention applies equally to children in the digital environment. So the convention was drafted in 1989, long before the internet became such a big part of our lives. But General Comment 25 was to reinforce that all of these rights still exist in the digital environment for children. Less known are probably the UN Guiding Principles on Business and Human Rights. These are not binding on states, but they were unanimously endorsed by states at the United Nations in 2011. They set out how states should protect children's rights when it comes to businesses operating in their territory, and also how companies should respect children's rights themselves. And they were informed by and continue to be supported by global business organizations, investors, leading civil society organizations, and national human rights institutions around the world. And they do have a relationship to each other. So the UN Committee on the Rights of the Child has recognized the relevance of the UN Guiding Principles to children's rights. And they've reinforced the importance of unpacking children's rights and child rights-based approaches to implementing the UN Guiding Principles in the digital environment. So this includes a duty to protect children from all forms of violence, including violence resulting from the use of digital technologies, and a duty to prevent children's data from being processed in ways that have adverse impacts on their rights. And states also have a duty to ensure children can access information, freely express themselves, and participate in civic spaces online, whilst also protecting their right to privacy. So that's a lot of things that have to all be done at once. So what's this got to do with age assurance? Well, states have a duty to ensure that technology companies protect human rights, and children's rights are also human rights. And technology companies have a duty themselves to respect human rights, including children's rights. And age assurance tools are used by technology companies to mitigate risks and harms to children on their platforms. And age assurance companies are also technology companies which can have adverse impacts on children's rights and broader human rights. So companies that design, develop, and deploy digital technologies need to proactively identify, assess, and mitigate adverse impacts on human rights. So that includes age assurance technology companies. And the United Nations Guiding Principles on Business and Human Rights provide a framework for how to do this. And they're aligned with international human rights law, including the Convention on the Rights of the Child. So what are the benefits to age assurance companies of aligning with international standards? So the UN Guiding Principles are not binding, but they are based on international human rights law. And international human rights law is translated in many countries around the world into national human rights laws. So there will be some legal requirements that correspond to the UN Guiding Principles. But they also help to enhance corporate reputation. So this is about trust. So if you follow international standards, you're more likely to engender trust amongst the public trust from regulators. I think in this technology space, trust is quite lacking, and everyone is trying to build trust as much as possible. It can also help to reduce legal and reputational risks. So regulators, like data protection regulators or media regulators, are not the only legal risk to businesses. Lawsuits can also be brought by civil society actors on the basis of human rights law. I'm not the kind of human rights lawyer who brings cases against companies, so that's not a threat, that's just a flag. And also the last one is contributing to a more sustainable and ethical industry. So I think most of us here today are interested in ensuring that industry remains ethical. And I think many people created their age assurance companies to do good and noble things anyway, so I know this will resonate with many people here. So the UN guiding principles are structured around 3 pillars: the state duty to protect, the business duty to respect, and then access to a remedy, which is both a state duty and a company duty. So the first pillar, the state duty to protect human rights. So this is all about the things that states must do to ensure that the public are protected from adverse impacts on their human rights caused by businesses. So states should apply what's called a smart mix of measures to foster technology companies' respect for children's rights. So this includes laws, regulations, and policies. So this is kind of the stick. And then also incentive-based means, so the kind of carrot approach. And also they should encourage voluntary measures. So encouraging some industry-led standards to supplement law and policy as well. And so what makes that a smart mix is getting the balance of those things right. So this is very relevant to our discussions this week. What's the right balance for states to strike in terms of regulations that mandate age assurance tools? So on the one hand, should they make them mandatory across the board, or should they also give platforms some leeway to decide whether to use age assurance tools at all, or if so, what kinds to use on a voluntary basis? And what's the right balance for states to strike in terms of regulating the age assurance industry itself, as opposed to industry standards led by industry that don't have the same kind of democratic public participation as the lawmaking process does? And the UN guiding principles also require states to ensure that businesses undertake human rights due diligence that identifies, prevents, and mitigates their impacts on human rights across their business relationships and within their global operations. So although age assurance may appear to just be about children's rights, it's important to remember that if adults must also engage with age assurance tools to prove they're not a child, then the focus must be on both children's rights and on broader human rights for all people impacted by the technology. So we're going to go into this company responsibility to respect human rights, which is pillar 2. So this is corporate responsibility, which applies to all business sectors, including the technology sector. And the guiding principles require businesses to embed human rights, including children's rights, into their policies and practices throughout the technology life cycle. So companies can't wait to make a certain amount of profit before they start to think about their impact on children's rights. The guiding principles state that the human rights due diligence process should begin at the design phase and before testing or launching of the product into the market. So small companies also need to carry out human rights due diligence. They need to mitigate any adverse human rights impacts based on the potential size and severity of the impact on human rights, not based on the size of their company. A small company could have massive impacts on children's rights or on human rights more broadly. And smaller and medium-sized companies can be supported to do this by taking part in multi-stakeholder initiatives and by cooperating with other businesses to save resources and scale their impact. So the Age Verification Providers Association is well placed to support all of the smaller businesses in the ecosystem with this. So if you're an age assurance company, you need to start thinking about human rights impacts during the design phase and keep reassessing these impacts as your product develops. If you're a platform looking to use an age assurance tool to mitigate a risk identified on your own platform, you also need to carry out an assessment of how the introduction of this new technology tool will impact children's rights and broader human rights. Technology companies should take a holistic approach, and this includes taking preventative measures to protect children from harms such as violence and exploitation, infringements of their rights to privacy, freedom of expression, access to information and education, while also addressing broader human rights impacts that might come into play. Now that sounds like a lot. So the human rights due diligence process is a process, it's a continual process, and it contains several elements. There's a policy commitment. So this requires businesses to have a clear, both external and internal policy endorsed at the highest levels of the organization, committing to embed in the corporate culture this human rights-based approach. The human rights impact assessment I will come back to because we're going to look at that in a bit more detail. Integration means that you integrate human rights considerations into all of the different corporate governance structures, policies and procedures and decision-making processes. Stakeholder engagement. So it's really important to engage with potentially affected stakeholders, including communities who may be impacted, other relevant parties, to understand their perspectives, concerns, and experiences regarding human rights impacts. Remediation, so you can get a remedy through the courts where people go to access compensation, but remediation for companies is broader than that, and it means things like having effective grievance mechanisms in place and processes to address any adverse human rights impacts that you might identify through the due diligence process. Tracking and monitoring, so making sure that you're assessing the effects of the human rights due diligence process over time and identifying emerging risks because the product is probably going to keep developing as the technology is continuing to develop. And transparency and reporting, making sure that you're communicating with stakeholders, which includes investors, consumers, civil society. And this can help again to foster accountability and trust. So we're going to focus a bit deeper on the human rights impact assessment. This includes 5 phases. So first, in identifying the use case, what are you using the age assurance tool for? Assessing the benefits. So what benefit will this age assurance tool provide in relation to the use case that you identified? Assessing the risks. So this is what risks might be introduced by the age assurance tool, and then weighing the risks against the benefits. And then finally, choosing a proportionate response. So first of all, identifying the use case. So what do we mean by this? Why do you need to know the age of your users? What's the harm you're seeking to prevent? So let's say this group of girls are all 14 years old and living in Germany. 14 was my assessment of their faces. I'm not sure how accurate that is. Why do you need to know that they're 14? Well, in many cases, governments are mandating the use of some kind of age assurance tool to prevent anyone under the age of 18 from accessing pornography websites. So if you own a porn website, to address that risk, you don't need to know these girls are 14, but you do need to know that they aren't 18 or over. What about knowing whether they're old enough to be on a platform to comply with the platform terms of service? Then you might need to know they're over 13 or a different age, depending on the platform. Or what if you need to know their age to comply with data protection laws in Germany that don't allow processing of children's data without their parents' consent under the age of 16? So each of these use cases is quite different and may need a different kind of age assurance tool. But whatever your use case, you need to be clear throughout this process of why you're using age assurance in the first place and keep coming back to that risk or harm you're aiming to prevent, because that's how you're going to do the proportionality assessment at the end. So the next step is to assess the benefits of the age assurance tool that you're using. So how will different age assurance tools prevent the risk or harm? What are the benefits of using this technology tool? So would it, for example, deny these 14-year-old girls access to a pornography website or a gambling website? Would these 14-year-old girls be grouped by age range, say with other children aged 13 to 16, and given a different online experience to those younger or older than them? If so, what will that experience be? How will that prevent them from harm or give them some other benefit? Or will these 14-year-old girls be given a different experience based on their exact age? And if so, why is that necessary and what will that be? Well, what is the benefit from that? And then once you've determined the benefit, you need to assess the risks of the age assurance tool. So what are the possible adverse human rights and child rights impacts of the age assurance tool? So the age assurance tool is being used to address one risk, but it may also introduce a new risk itself. And this isn't about risk to the business. We're looking here about risks to the human rights of children and the broader public. So companies need to pay special attention to adverse human rights impacts on individuals from groups or populations that may already be at heightened risk of vulnerability or marginalization. So we can't just say, well, we're going to protect the majority and there's these few people who are not going to do so well out of this, but it's okay because it's in the interests of the majority. We have to think about the people who are being excluded or further marginalized potentially. So this includes children, but it also includes adults required to use age assurance tools to prove they're not a child. So some examples that could be an adverse impact would be shutting children out of online spaces. This is not going to be a concern if you're shutting children out from a pornography website, but it could be a concern if you're shutting children out of accessing some kinds of information or participating in civic society. So shutting children out is quite a harsh line to be a harsh solution to a lot of less serious risks. Or you could end up shutting adults out of online spaces in error if they're determined to be a child when they're actually not. Or there's the danger of increased data processing from children and adults. So this is particularly relevant if you're using an age assurance tool to ensure you're not processing these girls' data in order to comply with the GDPR in Germany, for example. If you then end up processing even more data to prevent processing more data, it might not be the best tool. So you have to find a tool that's proportionate and logical in terms of the risk that you're trying to address. And these are just examples. There are many more potential risks depending on the type of tool being deployed and the context in which it's deployed. But that's why this assessment needs to be carried out for every context in which the tool is deployed, every market that you operate in, because the risks to children and other internet users in the UK are very different to those in different countries and different contexts around the world. So that's why you need to carry out stakeholder consultations across all regions, all markets that you operate in. So the lives of these Thai boys are very different to the lives of the 14-year-old German girls we were thinking about before. And they live in a very different legal, political, and economic context. And these are all factors that need to be considered in a human rights impact assessment. Companies that design, develop, and deploy digital technologies need to consider their potential impact on children's rights and broader human rights in all of the places and contexts where children may be affected by their products. And this responsibility under the UN guiding principles must be sustained even when it's not mandated by national law. So in some countries, the national laws will let you do many things which don't comply with international human rights law, but that doesn't mean that you should go ahead and do so. So it can be tempting when thinking about stakeholder engagement just to consult with groups you think will endorse your product. So for example, you may prefer just to consult with child protection organisations because they're primarily concerned with children's safety and will be more likely to endorse this product. But in relation to age assurance, there are many different rights holders who are impacted by the use of these tools in different ways. So you need to think about the differing needs and interests of children, their parents and caregivers, and adults in the broader population. And so taking a holistic approach will require consulting all these different kinds of stakeholders. For example, disability rights advocates. I think there's a presentation on Friday that will go more into the considerations for children with disabilities, but children could be excluded from age assurance tools based on AI not being trained on using data from their demographic group, for example. Human rights defenders and privacy rights advocates, they may push back on some of the age assurance tools, but it's better that you do that due diligence at this stage and understand those concerns and what the impacts could be, because if you just ignore them now, they will probably come back more aggressively later, I would say. And to note that internationally, age assurance interplays with broader internet governance frameworks. So one example, if you want to prevent children from accessing illegal content, it's important to remember that what's illegal in some countries is not in line with international human rights law. So for example, in many countries, homosexuality is illegal and accessing any LGBTQ content online is illegal. In many countries, sexual and reproductive health materials are illegal under broad pornography laws. So if you cut off children's access to that content, then they're not able to access really important information for their health. In addition, many countries criminalize online speech that criticizes the government or religion and impose prison sentences for this. It's absolutely not good enough to claim your technology is neutral. These factors of the context you're working in must be considered before selling or deploying your products in regions where they may cause adverse impacts on human rights. As well as political contexts, it's important to consider economic contexts. So take, for example, many countries in Africa where most children share devices with family members. In these same contexts, it's often harder for girls than boys to obtain access to devices. And the introduction of age assurance tools in those kinds of contexts can pose a barrier to girls if they're not designed properly for this context. So now, how to weigh all of these different risks against the benefit of preventing the harm we initially identified? Well, the UN Guiding Principles provide a framework for assessing these risks. So, excuse me. So you need to come up with a necessary and proportionate response. This seems to be a theme today of the speakers losing their voice. So after you've done the risk assessment, you need to look at scale. So this is related to the impact of the age assurance product and any adverse impact it has on human rights. So this is related to how widespread the impact is or the number of people who are impacted. Scope is concerned with how grave or serious the impact is. It's important to note that the Committee on the Rights of the Child emphasised that there's a particular gravity to child's rights violations because they often have severe and long-lasting impacts on child development. And remediability means whether or not the impact can be remedied to restore conditions to the person affected, so it's the same as or equivalent to their situation before the impact. So for example, if you're protecting someone from, if the adverse impact was related to a platform that is allowing child sex abuse on the platform, you cannot remedy child sex abuse to return the person to the state they were in before the abuse happened. You could if the adverse impact was some kind of financial consequence, you could give someone compensation that would put them financially in the position they were in beforehand. And then we have to choose a proportionate response. So if the age assurance tool is necessary, this means it must be proven to be effective for the harm that you're trying to address. And it must be proportionate to the risk or harm it's deployed to address. So you need to come back to the use case. What's the harm you're trying to mitigate with age assurance? And these three images are of children in very different circumstances with different ages who are exposed to different risks. Like, which of these risks are you trying to address? Are you trying to address all of them at once or specific risks here? And how will your age assurance tool do that? And considering all of these risks and the risks that you've looked at that your age assurance tool could create, what is a necessary and proportionate response? So what is effective, which makes it necessary? So this means effective not just in terms of it's effective in assessing the age of the child, but also effective in that if the platform knows the age of the user, they can protect that child. Is there any alternative, equally effective method to protect the child from that risk that doesn't involve any data processing? Even if the tool is highly effective, is it proportionate? So does it potentially cause minimal risks to children's other rights and to the broader population? Or does it potentially pose serious risks that can't be justified? And part of this assessment will need to answer what's in the best interests of the child. Measures that involve shutting children out of or really restricting their access to services that support the enjoyment of their rights are problematic and are not likely to be proportionate. If some of these rights come into conflict, they need to be weighed against each other. In some situations, protection factors might imply restricting a child's other rights, and these need to be assessed in relation to measures of empowerment of that same child. So the balance of protection and empowerment should be assessed in accordance with the age and the maturity of the child, including their physical, emotional, cognitive, and social development. You also need to consider children's rights to privacy and data protection. These are often portrayed as rights which mainly affect adults users, but these are also core rights under the Convention on the Rights of the Child and need to be taken into consideration for children as well. And also you need to consider the rights of adults in broader society. I'm going to try to speed up now. Pillar 3 is about the right to a remedy. I'm not going to go into a lot of detail on this. I can point you to some resources available from the Office of the High Commissioner of Human Rights, who are responsible for the UN Guiding Principles, which say a lot about how companies can work on their grievance-based mechanisms for the digital environment. Just to end with a few recommendations. The recommendations are that states should produce regulations which require technology companies to carry out human rights due diligence, including age assurance companies. That technology companies purchasing age assurance tools should first carry out a human rights impact assessment in each context they plan to deploy the tool in, and that technology companies providing age assurance tools should also carry out human rights due diligence throughout the technology lifecycle. And finally, to the Age Assurance Providers Association, that they could provide tools for age assurance companies to help them with the human rights due diligence process. You're welcome. Okay, thank you. Please contact me if you would like any more information on this, and I can send you further materials on it if you'd like to. Thank you. Yes.
Ian Corby from the Age Assurance Providers Association, as you put it. Just a quick question. I mean, it is a huge amount for, I mean, you would expect TikTok or Meta to be able to consider all these questions and do all that work. But for countless tens of thousands of smaller websites and apps, you know, this may be a bit overwhelming for them. What is a practical way for them to, you know, take all this into account? Should we yeah, I'm leading the witness a bit, but do you think this is where there is a role for the age assurance providers to do some of that heavy lifting for them in this area?
Yeah, I think so. I think it's possible to come up with a tool which would, I think mainly you're going to be prompting the questions that companies should be asking themselves, but there are going to be some common themes and common questions and maybe common answers as well. So I think there's assistance that can be provided. Yeah. I think a lot of small companies find it overwhelming, but if your business case is going to have some impacts on human rights, then you have to build that into the business model to address those from the beginning.
Thank you.
Thank you.
Anybody else? Oh, one more.
I'm going to ask first the obvious, and then there's a devious twist. Are governments bound by the same sort of assessments as well?
Yes, so the UN Guiding Principles, the Pillar 1 on states, does require governments to carry out human rights impact assessments when they introduce new law and policy. I think the relationship when it comes to kind of public-private partnerships is complex, but that should be integrated. Human rights should always be integrated into those kinds of arrangements.
So here comes a devious twist. EIDAS 2, which we all sort of know, has no implications let out for children. There is nothing about children, not about protecting them, not even mentioning them. Is that an oversight or is it worse than that?
I mean, I don't know what you mean by worse than that. I think it's an oversight, and I think it's common that children's rights are something that's seen as one paragraph or one concern to be addressed by a children's rights group, whereas they need to be integrated into everything, because anything to do with internet governance impacts children who are a third or more of internet users. So I think our governments and regulators have a long way to go in making that a reality.
I think it's even going backwards, because it's not even a symbolic attempt like in the GDPR. It's just not mentioned at all.
Right.
So how would you see that?
I think that the EU ID is aimed to be for adults and not for children at the moment, if I'm right.
No, because it's basically an online passport, and children
Right.
are in quite a few countries required to have their own passport. So logically, they would also be able to be required to have their own online passport.
I haven't looked at the EU ID from a child rights perspective, but I will look into it for sure. Can't answer that, I'm afraid. Thank you. Thank you.